You are sitting in a courtroom and the lawyer is not crying about a broken arm. They are talking about a guy who used to coach his daughter's softball team and now cannot lift a bat. That is the trick with quality of life damages. You cannot just say, "This hurt," because juries smell melodrama like a shark smells blood in the water. Quality of life losses are the fancy legal term for the stuff that does not show up on a hospital bill. Think about hobbies gone, relationships strained, simple joys like walking your dog without wincing every 5 steps. Here is the weird part. Juries are humans, and humans do not trust raw emotion. They trust patterns. So lawyers learn to translate feelings into something that looks almost like math, even though feelings do not actually have a formula. One classic approach is called the day in the life video. Instead of a lawyer describing pain, you literally watch someone struggle to button a shirt for 3 whole minutes and suddenly nobody needs a speech. Another trick is called anchoring, where the lawyer compares the loss to something everyday people already understand. Instead of saying, "This injury reduced his quality of life by 40%, they might say, "He used to run 5 miles every morning and now he cannot walk to the mailbox without resting twice." You might think exaggeration would help, but juries actually punish that instantly. The second something feels staged, like a soap opera in 1998, credibility drops faster than a phone with 2% battery. So instead, lawyers lean on specificity, because specific details feel true even when emotions do not. Saying, "She lost her ability to garden, which she did every Sunday for 22 years, hits differently than, "She's suffered greatly." There is also a strategy called per diem argument, where a lawyer asks the jury to imagine a small dollar amount like $50 for every day of suffering. It sounds simple, but it quietly turns something abstract into something juries can multiply in their heads like a homework problem. Doctors and therapists get pulled in too, not to say "this hurts a lot," but to describe function. Saying someone can no longer perform overhead lifting tasks required for his job sounds clinical, but clinical is exactly what keeps it from feeling like a guilt trip. Family members matter here more than people expect. A spouse describing how someone used to dance every Friday night and now just sits and watches adds proof without adding drama because it comes from someone who lived it, not someone paid to say it. Historically, courts worried these damages were too subjective, almost like asking the jury to guess a stranger's dreams. That is why modern strategy focuses on observable change instead of grand philosophical claims about happiness. You also have to avoid sounding like you are milking sympathy, because juries have radar for that too, sharper than airport security scanners. The goal is not feel sorry for him, the goal is, here is exactly what changed, judge for yourself. Doubt shows up constantly in these cases because juries wonder if someone is exaggerating for the payout. Lawyers counter that by using consistency, meaning the story matches medical records, family testimony, and even social media activity, since nothing kills a lawsuit faster than a suspiciously athletic vacation photo. At the end of the day, this is not about performing sadness. It is about translating a changed life into something 12 strangers can genuinely picture. When you make the invisible visible, you do not need to beg for empathy, because the facts basically do the emotional work themselves. If any of this made you curious about how real cases actually play out, or how to think clearly if this ever happens to you or someone you love, do you want to learn more about our company? Check out our links in the description.